Hello friends, in the series on income tax cases, today we will discuss a case which is based on section 54 exemption. The issue before Honorable Delhi High Court in the present case was that for claiming the exemption under section 54F, if the assessee invests in the name of a residential house property in some area which is a remote area and that land is agriculture land, and the assessee do not have any electricity or water connection in that premises, and only some plywood structures have been made which is not inhabitable according to the working conditions of that residential property. So whether in that case the exemption under section 54 can be allowed to the assessee. This issue has been taken up by the court in the case of Sandeep Huda versus Principal Commissioner of Income Tax and another. This case is reported in 475 ITR at page number 605, and the date of the judgment is 11th November 2024. As all we know that the assessee can claim section 54 exemption on the transfer of a residential property by investing the capital gain into a residential property, either in the form of purchase of that property or can construct that property within the prescribed period. But the main condition of this investment is that the investment should be in the nature of a property which is inhabitable and a dwelling residential unit. In the present case, the assessee has invested in an agriculture land. There was no electricity connection, there was no water connection. When the assessing officer was doing the assessment, he appointed an inspector to verify the premises. The inspector went there, made 2 visits. In the first visit, the inspector do not find anything there which can be termed as a residential house. And when the inspector made the second visit, in that second visit, the inspector found that there was some plywood structure, and there were 2 rooms. One room was in the form of a guard room, and the second room was in the corner of that property with attached toilet bathroom, but there was no water connection, there was no electricity. And when the inspector went to visit that property, the inspector found it very difficult to find that place. So on the basis of that report, the assessing officer disallowed the exemption under section 54. When the matter came before the CIT appeal allowed the appeal of the assessee, so the revenue moved to the tribunal. And when this matter was before the tribunal found that the assessing officer has made proper inquiry. There were no proper amenities, and the tribunal said that putting together the structure of plywood sheets could not be construed as a residential house. The tribunal said that in the present case there was no electricity, there was no water connection, and the assessee was using generator. The tribunal also found that in the present case the property was in a hilly terrain and the area was very vast where the property was situated, and it was uninhabitable. So from all the facts, the tribunal found that the order of the CIT appeal was perverse and erroneous. So the tribunal allowed the appeal of the revenue and denied the exemption claimed by the assessee under section 54. When the assessee moved to the High Court said that in the present case, the tribunal has rightly denied the exemption under section 54 because the assessee could not prove in the present case that the investment has been made in a residential house. The conditions for treating a property as a residential was not satisfied by the assessee in the present case because in that property no one can live there. At the end of this video, once again I am repeating the name of the case. The name of the case is Sandeep Huda versus Principal Commissioner of Income Tax, and this case is reported in 475 ITR at page number 605, and the date of the judgment is 11th November 2024. Thank you, friends.